Hi everybody, this is July 15th, 2025, and this video is part of my video journal of my recovery from watching my little brother, Paul Kierans, 65, with Down syndrome, be locked up by the British Columbia New Democratic Party government, David E.B. as leader, for 588 days, and then I believe, he died. He died alone. So he was locked away from me after I complained to the Burnaby RCMP about what I found to be, what I believe to be an alleged fraudulent and forged power of attorney that the group home, that the government actually created, appointing my 82-year-old Catholic nun sister 4,000 kilometers away in Ontario as Paul's guardian. And when I complained to the police, they ordered her to terminate permanently all his visits with me after 64 years of our visiting at will. We went to Newfoundland twice. We traveled to Seattle. I had him at my home on weekends, holidays. I grew up with him. I taught him to print the only word that he knew how to print. That was his first name, Paul. As a little girl, it took me about a year to teach him to print the only word he knew how to print or read. So, I've been struggling to recover. And after my brother died, then the evil nun back in Ontario, who the government had appointed guardian, applied to have me declared a vexatious litigant, which is a very unusual designation in court. It means it takes away all of your rights to defend yourself. So I can be sued and I can't defend myself. I can't file an affidavit. I can't sue anybody. I can't respond to any suit against me. And for somebody who practiced as a prosecutor for 3 years and then as a family lawyer for 23 years, you can imagine how horrible that is. I'm almost 70. It's not the way I want to end my career. So I appealed the decision. So what happened was they applied to have me declared a vexatious litigant. And they said the hearing was going to be 30 minutes, but instead they went in front of a judge and had it set down for 5 mornings. 5 mornings. And when we got in front of the judge for the hearing, I explained to her that I had a heart attack in 2016, and I've got 2 medical certificates saying I can't appear in court for longer than 2 hours per day. So on this first day, she went till 12:36, from 10 a.m. to 12:36 p.m. And then on the second day, at 12:06, I stood up and I said, I'm not allowed to appear here for longer than 2 hours. And she said, oh, can't you sit in the gallery? So other people have said she was daring me to have a heart attack right in front of her. Just truly another evil. She wanted me to risk my life. And she was just a very nasty, you just see this, you wonder how people engaged in the behavior of the Holocaust. Like, how could they, kill ordinary pregnant mothers and children and grandpas and grandmas? How could anybody do that? And it's if they have somebody telling them to do it, and who's in a position of authority, which this judge, her name was Judith Hoffman, must have had. She had somebody telling her to ram this. They wanted to have me declared a vexatious litigant because they knew the RCMP were investigating this fraudulent and forged power of attorney. So she just went ahead and she doubled down. Like third and fourth days were from 10 a.m. to 4 p.m., not even half days. So she wanted me to put my life at risk. And I went to the Court of Appeal, and the Court of Appeal of British Columbia invited me to appeal this decision, and I thought, that must be a good sign. And a friend of mine said, no, they just want to lock down all your options so you have no way out. they want to dismiss your appeals, all your appeals, so you have no way out. And I must have spent, 500 hours on the appeal, and the hearing was on June 24th and 25th at the Court of Appeal, and they dismissed my appeal on July 4th. They just said then the judge had the right to make the decision, saying that I was a vexatious litigant, and it was just like a sloppy, lazy decision. So I've had to do my third application for permission to appeal to the Supreme Court of Canada. And this is in this case where I've been trying to visit my little brother. This is the third application for leave to appeal to the Supreme Court of Canada. It's one of the worst miscarriages of justice in Canadian history, because it's again, both Paul and I are disabled, and it's a decision against both of us. But the reason I'm taking a break to post this now is because I feel really good. Today's the best I've felt. After I did the hearing at the Court of Appeal on June 24th and 25th, I took everybody that came to that hearing out for breakfast at the Wedgwood Hotel, which is the fanciest hotel locally. And I just thought, you got to make your own wins. Like, I didn't know if I won or if I lost, but I just wanted to have fun and celebrate as if I had won. And that's the way I feel now. So I buckled down and I started preparing this application. It's 20 pages long. And I thought, I don't even know what to say anymore. Like, I don't even know what to say to the Supreme Court of Canada. They just don't seem to give a damn. And I know all the mistakes that they've made. The worst mistake that I know of personally that the Supreme Court of Canada made was Guy Paul Morin was accused of murdering his next-door neighbor, 10-year-old Christine Jessup. And he said over and over and over again that he didn't do it. And a jury of 12 people actually acquitted him of the murder. And the Crown prosecutor appealed that decision to the Supreme Court of Canada, and they set aside the acquittal of a jury. I don't know if you know what the concept of double jeopardy means, but it basically means if you're acquitted of anything, they can't try you again. There's no double jeopardy. You can't be placed in jeopardy twice. But the Supreme Court of Canada set aside the jury acquittal of Guy Paul Morin. And of course, it turned out once DNA started to be used and he was tested for, they tested the DNA on Christine Jessup, they found that he didn't kill her at all. That it was a family friend of the Jessups that had taken her for a ride and murdered her and left her body in the woods. And poor Guy Paul Morin, I don't know how many years he was incarcerated, but they put him through hell. So I feel the same way. I mean, there's just so many. Canada has a horrific history of miscarriage, of horrible. There was a very recent one in Nova Scotia where a man named Glenn Assoon was convicted of murdering his girlfriend in Nova Scotia when he was in Alberta. But he defended himself, and of course he was found guilty of murdering his girlfriend when really it was a serial killer named Stephen McGray. But he was in prison for 17 years, and he was beaten up by the prison correction staff. He just had a horrific. And finally, they looked into it based on what a reporter did an investigation. They found out that it was a guy named this Mr. McGray that had murdered the girlfriend. And Glenn Assoon was given damages from out of your pocket, taxpayers' pocket, of many multi-millions of dollars, but he died 2 years after he was exonerated. So this is what I'm up against in my application for leave to appeal to the Supreme Court of Canada in Ottawa. But I came into the Vancouver courthouse yesterday morning at 9 o'clock, and I worked until 4 o'clock. And I think it was 7 hours. And I did the same thing today from 9 o'clock until 2:45. And I wrote my argument. And the gist of my argument is, in Canada, the charter, you have a charter right under Section 7 of the Charter, the right to life, liberty, and security of the person, that's your body, and the right not to be deprived thereof, except for in accordance with the fundamental principles of justice. And this judge that I was before, who declared me a vexatious litigant, was depriving me of my right to life, because my doctor said unequivocally in their medical certificate that I suffer from a potentially life-threatening cardiac condition and I can't be in court for longer than 2 hours a day. And she went ahead. So I don't think there could be a clearer case. She said that it looked like, based on my behavior, it looked like I had recovered. Yeah, you have a heart attack and you recover. So the hardest part of any legal work is developing your argument. Like, what are you going to argue? So although the government has the right to set aside any infringement of your charter rights, it's particularly hard to set aside a Section 7 right. So those 3 rights, life, liberty, and security of the person, are particularly precious and inviolate. And it's like you have double protection. Right in this section, it says, and the right not to be deprived thereof, except for in accordance with the fundamental principles of justice. So, and Section 1 says, these sections apply except for in accordance with the fundamental principles of justice. So the Section 7 violation is a particularly egregious violation because it's life, liberty, and security of the person, the most precious things that exist. And this judge was reckless as to my safety. I mean, my brother was already locked up for 588 days, and then he died. And then they're going to do the same thing to me, take away my rights, hoping that I'll die of a heart attack during the hearing. So I have finished the first draft of my application or permission to appeal this designation of me as a vexatious litigant. And your first draft, I mean, it's all downhill from there. It's just polishing. But the gist of it is that Section 7 right to security of the person is particularly important. And it shouldn't be taken away lightly, which is what this horrible judge did. I don't mind saying she's horrible. She's on the level of people who pulled the gas at Auschwitz. She was daring me to have a heart attack right in front of her. So I decided to stop here at McDonald's on my way home on the SkyTrain, just to let you know that things are going well. And I think there's about 2 more days of work left before I can file this application for leave to appeal. I have a really good feeling about this one. I'm just glad that I've got my argument figured out in my head. So anyways, that's it for today. I love you all. Take care, everybody.